Whenever possible, you want to avoid probate. And if by chance you are involved in a probate, it means a couple of things may have went wrong. To start, it may mean that either your heir or the person that passed away didn't have a will, and that's gonna thrust you into the probate process. It also means that you have a will and it has to get approved. And while probate is something that we can avoid whenever possible, if you have to go through the probate process, we want to do everything we can to ensure that it's as streamlined and predictable as possible. Well, how do we do that? We do that by having a clearly written will that will identify who makes decisions, under what circumstances those decisions are made, and that courts are used to seeing, that we're using a will that meets the statutory requirements, or the check boxes, if you will, that the clerks have to achieve and that the judges have to meet to allow the personal representative to be appointed and the will to be probated. And it's a long process. When a person's going through the process of probate, you're looking at 12 to 16 months with assets being tied up for at least a year. It can get expensive. Probate also gives family members and creditors the opportunity to contest a will, to say the person who wrote the will at the time they wrote the will wasn't of sound mind, or they were influenced by undue coercion, or when they wrote the will, it wasn't written in a way that it truly gave the intent of the testator. It was influenced or poorly written, or their intent was to do something else, but the will says something completely. So a poorly written will can almost be worse than not having a will at all. A poorly crafted will is going to create ambiguity. And we want to stay away from ambiguity because now it's going to be subject to interpretation. Call us today.